Us out here. My name is Matt Malone. I'm Chief Counsel over at the Contra Costa Superior Court. Among other things I do, I'm temporary judge administrator, public information officer, supervise the research attorneys. Today, I get the joy of the very, very dry legal portion of the seminar today to walk through some of the rules related to electronic filing, which actually I'm hopeful will answer some of the questions that we've received. Don't blame me. It's MCLE. I have to talk about rules, or that's the regulation. So I'm going to share screen here, and I'm going to walk through. You're going to get copies of all of this in the materials once they're sent. I'm going to walk through some one statute, several rules of court, and then and then reference a couple things local to us that govern e-filing, and again, hopefully in that context, we can answer a few of the questions that we've received. So I'm going to try this here, and Andrew, you're going to be my confirmation that I'm actually sharing a screen here.
Confirmed. Thank you.
Okay. So I want to start us with, and I apologize if it's showing up for those of you who are on maybe laptops. It might be showing up a little small. But I do want to go over a couple of these and highlight key provisions. The authority for electronic filing is here in Code of Civil Procedure, section 1010.6, and in particular, subsection E, which I will scroll to here. A trial court may adopt local rules permitting the electronic filing of documents subject to judicial counsel rules, which we will talk about, and certain conditions. The first question that we had gotten in a previous version of this for probate was, what do we do with originals, and what do we do with, what's an original essentially? This is answered here under subsection E1. A document that is filed electronically shall have the same legal effect as an original paper document, and that is the general rule for electronically filed documents. It becomes a little more complicated when we are talking about declarations or other items that are signed, and it changes depending upon whether they are signed under penalty of perjury or not. As you will see, E2 here and E2A in particular, when a document is signed but not under penalty of perjury, it's going to be deemed to have been signed by the person if it's filed electronically, and either the filer is the signer or the person signed the document pursuant to the rules of court. Now, I'll tell you, we'll go through the rules of court, but I'll tell you essentially that's either an electronic signature of some kind that identifies the signer, or it's that the signer verifies that an original is on file and can be produced. You'll see that the same kind of thing occurs in subsection 2B, which is under penalty of perjury. When the document requires the signature under penalty of perjury, declarations, affidavits, etc., it's going to be deemed to have been signed if electronically filed, and either you retain a printed form of the document and you can produce it. The rules of court get more specific on the timeframes for demands for that kind of production, etc. Or you use computer or technology pursuant to the rules of court. That is essentially a verifiable electronic signature tied to an individual. So again, with these provisions here for signing documents, e-signatures, electronic signature programs are very useful because they satisfy the majority of the rule. But I do get the question, when do we need to keep documents? You may need to keep them if they are documents requiring signatures and you're not e-signing them, and you're essentially a copy, because they can be demanded. I will call out also subsection E3. Any document received electronically by the court during the day, the actual day up until 11:59:59 is filed on that court day. This mirrors the federal rules on electronic filing. I have heard that there have been attempts at some local rules that would require filing by 5 o'clock in some counties. I don't know whatever came of that. Those are DOA, the statute controls. So you do have the full day right up until right before midnight. I'm going to, because I was a civil RA and because I supervise them now, going to caution a little practice tip here. Filing really late at night, while technically it means that document was filed that day, has practical consequences about what the court can do in terms of getting that document before the people who need to see it. The example that I will give, because the holiday is coming up, is a motion for summary judgment. For some reason, we still have the replies being due essentially, I think it's 5 calendar days before still. And the practical effect of that with an 11:59 filing is this. Your hearings on Tuesday the 30th, Monday the 29th is a holiday. Tentative rulings have to be up on the 26th, which is the Friday. In order for tentative rulings to be up on the 26th, which is a Friday, the RAs are going to have their work to judges on the 25th, which is Thursday, by about noon, which means if you're filing at 11:59 on Thursday a reply brief, it's going to be very difficult to get that before the RAs and before the judges. Particularly, the summary judgments are a particular issue there, and I, you know, if I were in charge, everything would be different. But keep in mind, there are advantages to filing those kinds of things a little bit earlier, even a day or two earlier, in terms of what the court's able to do with them procedurally. Last thing I'm going to talk about on this statute is 4E. We get a lot of questions about statutes of limitation and concerns about if I'm filing when the statute is about to run, what happens when my filing's rejected? You know, obviously, you know, there's a lot of issues that arise, as I know as a former practitioner in private practice, if these kinds of deadlines get missed. This is your provision on tolling of statutes of limitation for filing of complaints and cross complaints where statute of limitations are at issue. Essentially, if you file, okay, and you're told it does not comply with the filing requirements or is missing a fee, the statute is tolled for the period beginning the day which the court received the document as shown on the receipt, and the later of either the day you get the clerk's notice of rejection or you get the ESP's, the electronic service provider's notice of rejection, plus 1 day. So what that means is you get the rejection, you have a day to fix it, whatever the issue is. And that's a tolling provision designed to protect from the exact kind of concerns that animate the questions we get about statutes of limitation. So it's very good for practitioners, filers, people assisting practitioners in filing to be aware of that provision. The last thing, I'm not going to go to it, but obviously subsection G is what allows us to require electronic filing in civil actions. We do have mandatory e-filing in civil actions. And then, of course, it's subsection 4 there. Unrepresented persons are exempt from mandatory electronic filing. We have had questions come up before about the equal protection consequences of this. Very quickly, anybody can be unrepresented, so it's not an equal protection issue. We are sensitive to the fact that there are filing fees associated with mandatory electronic filing. Unrepresented persons are exempt and don't pay those. But as someone who used to practice, I'll tell you those fees are nothing compared to, I couldn't even tell you what I filed by mail when I was in practice. It might have been CMC statements. Everything else was couriered or overnighted or other kinds of methods. And those fees, you know, at worst are comparable and at best are much greater than what you're paying for electronic filing. So that is essentially the key provisions of the statute. We're going to move to, I'm going to move quickly through the rules of court. We have, I'm going to, again, these will be in your materials. Rule 2.253 is what gives us mandatory electronic filing rules. The key points here are that the court has to specify the types of civil actions where there is mandatory filing. I will come at the very end. You can see a little thing up top, current e-filing standing order. I'll talk briefly about the categories that we have as e-filed, but that's primarily informative for you. That's the rule that governs it. We moved 2.254. Again, this is primarily informative. We are required as a court to publish the electronic filing requirements, which we do through the standing order. And I'll walk you through how to get that off our website. There's a local rule that also generally sets up the process. And if the court's aware of a problem that impedes or precludes electronic filing, this is subsection B. We have to promptly take steps to provide notice, and we do so when we get those kinds of issues. Our primary point of contact is the Bar Association for a notice to as many attorneys and filers as we can at once. Then we will go to 2.257 or 6, excuse me. Let's see here. I have these. Oh, there it is. Responsibilities of an electronic filer. The one thing I want to call out here is, and I would encourage you if you're filing to read this, is under the format of documents to be filed electronically. There is a requirement, and it's the format adopted by the court. Documents have to be text searchable where it's technologically feasible. Again, just something to be aware of. I think most of the stuff comes in, and Andrew can probably correct me if I'm wrong, text searchable anyway as a result of our e-filing system. But sometimes we get, well, where's that requirement? That's where it is. We'll spend a little bit of time here on 2.257. This is the electronic signature rule. It largely tracks the rule of 1010.6 we discussed earlier. It does define electronic signature. It does, when it was signed under penalty of perjury, 2.257B, 2 sets up the process, and I'm just highlighting it to show you the process for when you are not electronically signing a document, what you have to do to make, to both retain and to make a motion to produce an original if that comes up. I haven't heard of this coming up quite a bit, not that I would necessarily, but there is a process there, and it's good to be aware of it. And again, the documents not signed under penalty of perjury largely tracks the statute. Just again, to be aware of it. Electronic signatures are your friend for a lot of these rules. The last applicable rule of court here is Rule 3.1110. This is not specifically an electronic filing rule, it's a general formatting rule. But one thing that comes up quite a bit under format of exhibits, subsection F, is F4. This concerns electronic exhibits. And again, self-represented parties are exempt from this, but electronic exhibits must include bookmarks with links to the first page of each exhibit and with titles that identify the number or exhibit number or letter and briefly describe the exhibit. I cannot tell you how important this is for large MSJs, cases with administrative records, anything where the exhibits are large. Sometimes, I've seen it arise in anti-SLAPP motions where there's just a ton of exhibits because there's a lot of stuff that happened and people and filers have included a lot of it for context. A exhibit filed without bookmarks that is 600 pages, I'm not going to say might as well be filed in the trash. It will be reviewed, but keep in mind, it makes it so much more difficult for research attorneys and for judges to navigate an electronic exhibit when there aren't bookmarks. And it's also important that the bookmarks are accurate. So I do want to call that out because while I don't know that anything's been rejected, I do know that we have had judges in tentative rulings call out failure to comply with this section because it is such an important, it's a tool for the court that allows it to navigate these large documents and give each of the exhibits the attention that is really needed as called out in memo of points and authorities or elsewhere. Okay, I swear I'm almost done. This is our website. This is the Superior Court of California website. Under online services, civil e-filing. That is where you will find this page. This is our civil e-file services page. It has a link to the portal. It has our e-filing overview. It has our FAQ and instructions, FAQ and instructions, and it has links to our local rule and to whatever the current version of our e-filing standing order is. So might be useful to bookmark this when you go there. Again, our homepage, online services, civil e-filing. I won't spend time on the local rule. It's very straightforward. It just sets up the general guidelines for mandatory electronic filing and service. And then the last thing I'm going to talk about is our e-filing standing order. This standing order, linked on the previous page, sets out which cases under civil and which documents are to be e-filed and which are to be filed in paper. I'm not going to go through every case type here. I would just encourage you to look through it. There's a section on what documents may not be electronically filed. There's several documents, restraining orders, certain bonds and undertakings, bench warrants, etc. And then each case type, civil, complex, probate, family, has their own section. What I will say about this is we have generally accepted ex parte motions and oppositions from e-filing, but I do anticipate that we will require e-filing of particular ex parte motions that don't require hearings, that aren't, that are more are better subject to e-filing. I expect that to include ex parte motions to serve by publication, a couple other things like that, serve the Secretary of State. And I do expect that we will have an exception here for ex parte stipulations. Stipulations should be electronically filed. We have had people come in with ex parte stipulations, so they don't have to e-file them. I expect that those kinds of ex parte motions will be exceptions to this exception, meaning they will have to be e-filed. If and when the standing order changes, it will be updated on the website. It will be we will give notice out to certainly the Bar Association and local other local entities that an updated e-filing standing order has issued, and then the Bar Association is very good about putting that in the e-blast. So if that changes, you will know. And that is going to do it for the sort of law portion of this. I'll stop sharing. And now we're going to turn it over to some more practical tips about e-filing. And I will turn it over to Andrew.
Okay. For anyone who doesn't know who I am, my name is Andrew Adams. I am the court operations manager for the civil and probate clerk's office. That also includes small claims, unlawful detainers, restraining orders, name changes, a whole bunch of different things. So I kind of want to talk today things to make e-filing quicker and more manageable for you guys, because the one thing I hear all the time is, when is my stuff going to get filed? When is my stuff going to get filed? And my goal is to get your stuff filed every single day. Is that a reality? No, it's not. But there are some things you guys can do on your end that definitely speed things up for my staff when it comes to naming documents and giving us information and comments and things like that. I'm going to actually show you what the clerk's office sees. So when we kind of talk to you, or I've talked to you on the phone or in person, you kind of have a little bit better understanding on when we're saying we're missing information, what we're talking about. Okay. So I have a little bit of it's a small PowerPoint presentation that I think will answer a lot of those questions and give you some feedback on things that'll speed up e-filing for you. Okay, give me 1 second. So, all right, Matt, let me know if you see that. Excellent. All right, so e-filing overview. Matt talked about a lot of this, but I'll just kind of point on it again. E-filing was mandatory starting 7/5/2022 last year for that local rule. As Matt said, there is exceptions for self-represented litigants, or any party can move the court for an order exempting it from that provision. Matt also talked about the fourth standing order regarding e-filing, and was signed on 10/19/2022. As Matt kind of discussed, as we've learned e-filing, it's a new procedure for us. I know we're almost a year into it, but we are learning as we go. So the fact that we've amended it 4 times lets us know that we've learned some things don't work in e-filing or aren't that practical. So as we get more information, or as we start reviewing more policies and procedures, that's when we kind of put it to our bench going, I don't think this works that well in e-filing, or maybe this should be in e-filing. So there are discussions out there going on about updating some of this stuff. And when that does change, we will let you know. Some of the examples of things that aren't allowed to be e-filing currently are writs of execution and possession, mainly because those sheriff's offices, those Even with abstracts of judgment, those recorded office, they want to see originals. They want to see signatures. They want to see blue stamps. Those are all being issued. Same thing with ex parte motions, oppositions, all that stuff has to come in and actually be reviewed by the judge before filing, and that's why it's not available on e-filing. Same thing, peremptory challenges aren't allowed a lot of the times, like if it's a 170.1, the judge has to be served anyway, so you got to come here anyways. And a full list can be found on the current standing order. And I did include the 2 links below. After this presentation, this is available for you guys, and I did tell the bar that they could disseminate this to everyone so you guys can have a copy of this. Maybe it'll be helpful for you or your staff. Okay. Some of the tips. So when we're looking in e-filing, one of the things my staff does every day is we constantly have a queue of around, just for civil, around 2,000 filings. And when I say filings, that means an envelope. Each envelope can have up to 1 document. It can have up to 40 documents, depending on the size, as long as it's not bigger than 25 megabits. So going through those, making sure that we can pull out documents that are coming up for like court hearings is really important to us, specifically for the judges and the RAs. So looking for like oppositions to motions, replies, objections, reports of counsel, things that I know that the judges are going to need to see to be able to like continue their court hearings. So when we look at it, one of the things we've asked before, and this went out as a blast to all the e-filing providers, was that when you're describing your document, you include the next hearing information. So next hearing 5/17/23 at the beginning of the title of your document. The reason that's important is when we're looking through the list of them, we can quickly see when I go through all the documents that came in yesterday. So if I'm looking through yesterday's filings and there's 243, I can quickly go through and go, okay, all of these ones I'm going to get done because they're within a week and they need to get done because someone has to see them. If it's just saying declaration, that's not that helpful for us because then we have to go and click. If it's not coming up on our calendar, I'm going to move on until something that's really going to be more time sensitive. Okay. The other thing, the document description besides that next hearing piece should match the document title. So when you have a declaration, it's a declaration of Andrew Adams regarding OSC for failure to appear, your document description should say that same thing. A lot of times I see the document title and then the document description just says declaration. Now, that whole description part that I'm talking about, that's what the judges see. And so if that's not inputted when we get it from you guys, my staff has to spend time going there and actually updating that information so the judges know what they're looking at. One big hotspot for that is motions in limine. I hear time and time again about the judges going, I have 30 motions in limine. I don't know if this is the defendants. I don't know if it's the plaintiffs and which one it's against. Or so titling your documents is very, very important. Also picking the correct security level. When you're submitting a document in e-filing, it lets you choose confidential or public. 99% of the time, your document should be public. If you accidentally choose confidential, we can fix it in the clerk's office. It just slows us down a little bit. Okay. Another thing, make sure the document is legible. Sometimes we've seen things that are they're photos and they get uploaded as PDFs and they're not very legible because they're off kilter or they're just so granular. It's just difficult to see. The other thing I'd ask is if you have special notes for the clerk's office, please include them in the comments to court box. A lot of the times it could be you're asking for a hearing date that's not that normal for us, right? And so if you have a CCP code section or rule of court that tells us, hey, this has to be set within 5 days or 30 days or whatever it needs to be, we get that little note from you. It's easy for us to look it up, talk to the judge, take appropriate action. Same thing if you had like a special thing set up with one of the departments and they've said, yes, you can file this and it doesn't conform to our normal procedures, please include that information. Because otherwise we're going to look at this thinking, this doesn't comply, we're not accepting this. Okay, so that's very important. Let's see. So this is what the clerk's office actually looks at. So this is the current filings from, I want to say a few days ago, unlimited subsequent filings. We have multiple queues with multiple different types of filings, whether we have initial filings, we have subsequent filings, and that all breaks down by case type as well. Some of the things you probably heard when you call, when we're talking to you guys, we're asking for the envelope number. This is the envelope number right here. This number is specific to your set of documents. Now we can do searches when we're looking in e-filing, we can filter by quite a few different things. Envelope number is the best one if you want us to know exactly which documents you're talking about because it relates directly to that filing. Now, we can also search by case number, but what it's going to do, it's going to pull up anything associated with that case number. So if there's a trial coming up and there's 30 things pending out there and we have to search through and try and find which one yours is, we can find it. It's just going to take more time. The other thing you can see on here, we have our submission date, which is right here. The other is status. So I've had a lot of questions about this, about what is the status of my filing. There's a few different statuses. So the first one you're going to have is called submitted. And submitted is when you've sent it to the court, it's in our queue, and we have not touched it yet. Now, if a clerk goes in it, touches it, opens it, says, I can't file this right now, or it's 4:30, I got to go home. They're going to close that envelope, and you're going to get a new status update of under review. If you ever get one that says under review, that means we've looked at it, not necessarily processed it yet. So whether there's a computer error, or there's some technical issue, or there's something we have to work out with the department about something with the filing, it's possible, or we just haven't had a chance to finish it up, which is also there. The other thing you'll see is you'll see accepted. If it says accepted, it's your status. That I think it's pretty intuitive. That means that we have accepted your filing and it's going to the court. Now, I will tell you, when we accept things in e-filing, when we accept them, it's not instantaneously. It takes a few minutes for it to actually process, where this e-filing system takes it and actually moves it over to Odyssey. So the clerks, a lot of times what we have to do is when we accept something in e-filing is not perfect. It doesn't do all the little extra steps we normally do as a clerk, where we mark someone as served or someone's been defaulted and we can make that note in the system. A lot of times we have to wait for that process to happen, then go into our case management system and do the updates. A good example of this is if you do a notice of change of address, we'll file the notice. It's great. It doesn't actually change anything in Odyssey unless we go in and do it. So there is a lot of double checking for the clerk's office to make sure that your filings are accepted and then the system's updated appropriately. So anything we can do to speed up the acceptance process lets us work on the other piece. Okay. Earlier I was talking about filing description. This is the filing description right here. So a lot of times you'll see it looks like this first one, for example, it says proof of service and the description is proof of service. As I was saying earlier, if you include that when your next hearing is, so this proof of service, for example, if you put in here next hearing 5/19, I'm probably going to get to that one really quickly, especially as of today, because I know it's coming up and the judge is going to need it for calendar. So that is very, very helpful. Some of the other things is when I've had people ask questions about, like, how do I make sure my documents are filed timely? As I was saying, we do that daily triage when we look back to the previous day's filings to make sure if there's anything that's not coming for court. We try and catch as much as we can. If things aren't labeled quite right, it makes it a lot more difficult for us. The other thing we also do is we have our clerks in the back when they actually prepare the calendars for the judges. They go through e-filing and try and find anything that's associated with those cases that are going up for court. A lot of times that helps by there's a notice of settlement in there that we didn't know about, because those aren't generally always immediate, because sometimes the hearings stop for 3 or 4 months. That lets a clerk find it, enter it, and then you don't have to show up for court and the judge doesn't have to call it. Okay. This is a really good example. This party right here, they did exactly what we're looking for. As we're going through this, if I'm going through the day before I'm doing triage and I see this, and let's say it's December 5th or something like that, I would see that immediately go, okay, this is important. I got to take care of this. Putting that next hearing thing lets you sort through that giant list. And I'm going to go back one slide just so I can show you guys one thing. If you look down here, this tells you how many we have sitting here. There's 469 individual envelopes at the time I took this waiting to be processed. So ensuring that you describe your documents properly if there's upcoming hearings is very, very important for us. And it can save you a lot of time. It can save us a lot of time. So there's that. All right, this is what it actually looks like once we go into one of your guys' filings. Now, what we're looking for is there's a few different things. You're actually going to pick a filing code, right? In a filing code, you're going to have a list of codes. The code is the same across the board for all e-filing providers. Now, that will be different between civil, between probate, between family. It's all controlled by the court on basically what we want to have available there. We try and keep it simple. So a declaration is a declaration, and then you would fill in what the declaration is. We don't want 30 different types of declarations, and we're getting questions all the time going, which one do I need to pick? If you're not sure of what to pick on a filing code, pick whatever you think is closest. or you can pick something called miscellaneous filing. If you pick miscellaneous filing, basically what it tells the clerk is I have to look at what they're submitting, that it doesn't quite fit whatever they were filing code they were trying to use. And we can figure out whether we can actually find the correct code or if we need to switch it once it gets to Odyssey. The main important piece is we want your document, the name and all that stuff we can fix later. But if there's any questions about that. Now we've talked about filing description a lot. It's right here. This is the filing description part. So that's what comes over when you guys fill in your filing description. So whatever you put here, we would like to match this part. Right? Now, of course, I'd want the next hearing date right here, and it's quick and easy for the clerk just to take that out and delete that and move on with their lives. And then we have the document matches the filing description exactly. So if the judge is looking in their judge edition and they're looking for a declaration of attorney regarding amended reduced reserve amount, their description is going to say the exact same thing without the judge having to open it. This has been a big thing with a lot of the judges. If we don't title things properly, they get very frustrated when there's 15 declarations in a row and they're not titled properly, or they just say deck of plaintiff, deck of plaintiff. Then they get very frustrated trying to flip through all those declarations and figure out which one you're actually talking about. The other thing is document description down here. We would want to be the same as the filing description. This is actually really important for appeals when we're building appellate records, because when we're building appellate records, when you guys are designating documents, when they're going through and they're pulling it based on the document description, if it doesn't match this, they're going to have a hard time finding what you're looking for. Now, I will say on one thing is in the filing description, there are a lot more characters you can use there. So use as many characters as you can. Documents descriptions are much smaller. So if it needs to be an abbreviated version, that's fine. As long as you're able to look at the two and you can tell this document description matches that filing description. That's really what we're looking for. The other thing I talked about earlier is that message to clerk. So right here is where that message to clerk pops up. That's really helpful. I get this question a lot for motions. If you're not available for a law and motion date, how do I let the clerk know? That is how you let the clerk know. You put it in this message to clerk saying, hey, I'm not available on these days. And we will avoid those dates for you. A lot of times in probate, I get things like, hey, I have a special exemption from the probate examiners and they fill it in there. Or I spoke to Department 21 and they wanted this filed by XY date. And then I can check with the department and it's very quick and easy. It's very helpful. Same thing I said, like if you have a code section that governs something that's not quite a usual filing or might be out of the ordinary for us, please include that information there. We do read those comments. Okay. All right, let's see. Oh, some of the common issues / rejections we talk about a lot, or I see a lot, is the first one I'd say is the party has a fee waiver and that payment type is not selected. So if they do have a fee waiver, one thing you have to do when you are setting up e-filing is when you put in your credit card information, you create that payment type, you also have to create a payment type for fee waiver. There are instructions on Odyssey's website, and if you actually look at the very bottom link down there, if you actually type in fee waivers and how to create one, they'll tell you. Now that link at the bottom is actually very good for a multitude of questions. Any type of technical issues you guys are running into, document size, PDF types, security types, all that kind of stuff, that will answer for you. It has very good information and it shows you detailed like processes of how to actually do each one. All right. Some of the other things I'd say is filing submitted matters into a subordinate case on consolidated actions. If you do that, a lot of times what will happen is the clerk will actually accept it and the filing will reject out. When it rejects out, it doesn't tell you, it just tells us. And then the court has to go back into it, figure out what happened to it, and then we have to send it back to you and say, hey, please submit into the master case. Okay, so that's something we see. It happens more on things like CMCs where those have been consolidated. Just make sure you're using the master case number. Another one is large exhibits that are broken up and submitted without cover pages. I do know that there is a restriction on the size of the documents you can submit. We are aware of that. So what you do to kind of bypass that is if you have a really large document, what you need to do is take it and break it up. So if you have, let's say this is exhibits in support of MSJ, right? Call it exhibits in support of MSJ part 1, the next filing, and it has more of the exhibits behind it, part 2. Just make sure you have a cover sheet on there that the clerks can actually file. Okay. So some of the judges brought this up to me is multiple documents being uploaded as one PDF. And specifically, they brought up good faith settlements, where we have the notice of settlement, the declaration, and the order all submitted as one PDF. We can't take them like that. And the courts, in the clerk's office specifically, doesn't have a way of breaking that filing up for us. So when you're submitting a document, make sure each document is its own PDF inside of that envelope. If you don't, you're going to experience a rejection saying, hey, this is all one document, we can't file this. So something to keep in mind. Another one is amended filings that are submitted but aren't identified as amended. A lot of the times, like there was some small issue on your complaint and you're resubmitting your complaint, and technically that's a new amended complaint at this point. And if what we'll actually do is we'll look at the original one we have in our system versus the one we're getting. If it's the same or it's not saying anything different, we're going to reject it as a duplicate. If you have amended filings too, and it's not that clear, that comments, that message to the clerk section that I talked about is a very good place to put like comments to us about why is this coming or why are you doing this? Okay. Another one is we get subsequent pleadings for a case that are filed as a new case. So when you are actually going into e-filing, you have two options. You can either file into an existing case or start a new case. When you have documents for an existing case, you have to file into the existing case. We tried to do some workarounds around that at the very beginning, but when you start as a new case, it's going to want to charge you money. It's wanting to give you a new case number. Even if I change it to the existing case number, we get rejections saying duplicates. And so it's something we don't have any workaround for that. You have to make sure you're filing into your existing cases. Okay. As I said before, that link at the very bottom is an answer to many common e-filing submission issues. A lot of the times, even my staff, we get calls regarding technical issues, and we'll pull up that website and we'll type in the question because it gives very good answers, very, very helpful. So I would advise you to use that. Absolutely. Some of the other questions that I don't think I went over that got submitted beforehand is there was a question about proposed orders. When submitting a proposed order, the vendor said that the court does not allow them to be lodged, the proposed order, and that they have to take the proposed order to the clerk. So I don't think that's necessarily true. For law and motion matters, we do lodge the orders ahead of time. Same with probate matters, we lodge the orders ahead of time. But a lot of times in law and motion matters, even if we get the order ahead of time, if they grant it, they're going to want a new order that's coming later anyways. Most of the time, it's going to want the tentative ruling attached or a proof of service with that 5 days showing that you waited for the other side to oppose. So while we do have the original, generally the court is looking for a new one at that point. For probate specifically, I know I had a question here about probate, about Department 30 and 15's orders. For them, if you have orders and you want to get copies back and stuff like that, you can always send a copy of that with an envelope to the probate examiners. They'll hold on to that stuff and take care of it after the hearing, okay, if you're not coming in person. Let's see. We got a question about UDs and how they're supposed to be expedited matters, and why there's not currently. We do consider UDs as a priority. We do have a whole unit dedicated to them. I will say that's subject to the amount of work we're getting and the amount of staff we have at any given time. Currently, right now, I think Martinez is the most backed up right now, and I am requesting assistance from some of the other courts who are very caught up to address that issue, so we can get those filed more timely. It kind of goes in waves where sometimes we get a lot and sometimes we don't. So it's something we try and address on a daily basis. And while talking about UDs, there has been some question about clerk's judgments and writs of possession. Because currently the clerk's judgment would need to be submitted online. The clerk would file it, and then you'd get it back in e-filing. Then you'd have to bring in the writ. Matt and I have talked about this issue a few times, and we're looking into possibly changing that procedure because it does make some sense to have it all be brought in at the same time, since it is kind of a one and done thing. Okay. Next question I got is, how do you obtain certified copies of our documents? Currently, what you'd use is court records. Now, for civil, most stuff you can't get certified online, but you can get copies for free online, conformed copies. Now, for things like orders, I know a lot of people want certified copies of orders. The issues we run into is we do have a function in e-filing. It's called other services. It lets you pay ahead of time for a certified copy the pages for it, and an envelope for it to be mailed back to you. And that's all in other services. Now, for orders, the problem with that is you're getting charged ahead of time. So if it gets charged and then the court decides not to file it or not to sign the order, then you're sitting out there and I have to do a refund for that. So that's an issue. If it's like a document that's just being filed and it's like a one and done, like maybe a notice of lien and you need to record that with the recorder's office, you could put in the clerk's note, hey, requesting certified copy after file. As long as you pay those fees, once we're done, we'll print it out, we'll certify it, and we'll send it right back to you. It's kind of those one and done ones that work the best that way. Orders, those, like I was saying, I can see some issues with there, and that's why we generally have to wait on the certified copies right there. Let's see what else. I kind of talked about writs of execution and abstracts. Those all have to be done in person. Sheriff's departments, recorder's offices are all requiring those as official signatures and seals. Let's see. Oh, another one I got. So is there a way to withdraw a pleading after it is sent to the e-filing entity, but before it was actually filed? Now, I will tell you on the court side, it's very easy for us to reject one and send it back to you. So if you call, let us know. We'll put a little note that we spoke to someone and send it back to you. There is a way you can cancel a request. Now, I've told this to a lot of people, and I've heard back from a lot of the vendors that the vendors won't do it. They will make you call the court and have the court do it. So if that's true and that's what the vendor's telling you, you just call us, give us your envelope number, let us know which filing it is. We haven't actually accepted it yet. I have no problem sending it back to you. We just want to know who we spoke to, and we'll put it in our rejection letter so there's no issues. On that note, so one of the very good things e-filing does for us is it keeps a very long list of all the documents that we process. So whether it's been accepted, rejected, all that kind of stuff. So when I get calls about rejections that are perhaps an error, I am able to go back and look at the original submission, and I can see the original submission date. So when someone's worried about a statute of limitations and they think the clerk's office screwed up, and maybe we did, I mean, training is always an issue and it's an ongoing thing. We do have the ability to go back, look at the previous filing, make sure there was no issues with it and there was a court error, and then you can resubmit it and we can fix it and give you that original submission date. That's not an issue. Same thing if you're submitting, I've gotten this call many times, if you're submitting a new complaint and your statute of limitations is coming up in a day or two, you can give us a call. It doesn't necessarily mean it's going to get processed right then, but I have no problems looking at the document, making sure there's no problems with it, and giving you a little peace of mind that it's going to be processed. There are other people in front of you, so those people will get processed first most times, but at least I can give you that little bit of reassurance that there's nothing wrong with your filing. We'll file it when the time comes. Okay. Let's see. Another question is, what pleadings can we file at the clerk's office? The standing order really talks to that. A lot of just basic ones are writs of execution, abstracts. If you need a subpoena issued, a citation issued, bonds, wills, things like that. But the standing order goes into detail about all that kind of stuff. So I would advise you looking at that. Absolutely. Let's see. One of the questions we got was about, I recently was advised of the possibility of submitting documents to be lodged with the department for a future adoption hearing. I simply sent them in as a filing with a note to the clerk. Is that the way to do it? Now, I can't speak about family law adoptions. I just don't handle that type of law. I've never done that. But if we're getting documents that need to be received and they're specifically to be received, and let's say you have something from one of the civil departments saying, hey, I want this letter, I want that sent in to me, and the judge is telling you they want that document, you can, of course, submit it. You can submit it and use your filing code lodge order / whatever, and we can call it whatever it is. And that's basically us just receiving the documents and they just sit there. So we do have ways of doing that, where we would actually take off the filing ribbon and we put on a little receipt stamp. So that is possible. Now I feel like that question is a little bit more department by department basis. I know a lot of the judges, even when you are filing things, still want to see courtesy copies, depending on how soon you're filing it. I know 36 definitely wants to see courtesy copies. And then you have Department 18 who doesn't want any courtesy copies. So a lot of that's dependent on which judge you're working with. Okay. So make sure you give that department a call. Let's see. So we kind of talked about the statute of limitations, and Matt did. If something gets rejected, you do have that extra day, which is great. Another question we get is, how do we know when the e-filing is going to get, when is my submission going to get filed? And that really depends on backlog. Okay, limited civil is absolutely more backlogged than unlimited. Unlimited civil sits around 2 weeks, but with the caveat that we do go in every day and we look for things that are priority issues to get filed ahead of time. Okay, a basic proof of service is not going to take a priority over, let's say, in opposition to an MSJ. We have to get the MSJ done first. So trying to balance those two things is what the clerk's trying to do. And what we have done to try and balance out the load is every department has its own clerk assigned to its e-filing. So those clerks are very familiar with the cases, and it has actually led to an increase in speed for processing documents. So that's been working well. Limited right now is about a month behind. Still, even if something's coming on calendar, the clerk's office is going to be looking for that to try and get those things filed for you guys to make sure they're there and available for court. I know Department 9's clerk does her own checking too, and I'll get a whole list of stuff from her every once in a while about, hey, can you file these things for upcoming hearings? So there are people looking for those kind of things. Probate is about a week, sometimes a little bit longer. And every once in a while, I'm giving you these timeframes as kind of base values. These can always kind of change depending on staffing levels and, you know, if COVID happens or something like that. But we do have outline ones where, let's say you've had a new complaint sitting there for 3 weeks and you're going, Andrew, what's going on? Many times there's two issues. Either there's a technical issue with Odyssey through Tyler and where you have their developers working on it to make sure your filing gets handled appropriately, or it's a case type that we didn't put in e-filing. Now, I did my best to make sure we had every case type in there. But as a lot of you know, civil has a ton of things you only see once every few years. So trying to remember all those different case types has been a challenge. But as we find those and we add them to the system, we will keep your same original submission date. Okay. And we have had issues where sometimes the tech piece is just taking too long. And what we'll do is we'll print out your documents, we'll file and send you a letter saying, hey, you owe us a check for the filing fee. So we do have ways around those things. So we're trying to address those as they come. All right. Another question was about documents that are more than 10 pages. I think I spoke to Matt about this, and we're thinking maybe if it's large briefs. The clerk's office isn't looking for anything like that. We're not looking at page count to see whether or not that complies with brief requirements. We'll still take it and we'll file it. I mean, if you're concerned, you can always do an ex parte for filing of an extra large brief. I saw a lot doing appellate stuff. I don't see that as much as civil, but you could do that. The other thing is, we don't know if we don't know if the document's actually filed, who do we call? You can always check in with your e-filing provider. They should be able to give you that status. So as I talked about earlier, if it's accepted, it's accepted. You're fine. Submitted, it's just waiting to be processed. If it's under review, that means the clerk has touched it and not necessarily finished it. If you have a further question, you can always call the clerk's office. If your e-filing provider told you it's submitted and you ask the clerk's office, we're going to tell you the exact same thing. It's submitted. So it's really up to you, your choice. But generally, those status updates are accurate, so you can trust those. The last big question I had before we get into any questions from today was, where do I find a list of the e-filing services to choose from? So Matt showed you earlier the court's website when it talks about civil. Up in that civil right-hand corner, there was a civil e-filing portal. That leads you to a list of providers. So I believe there's over 124 different providers in the state of California to pick from, and you have to pick one of those. And so speaking about providers, and I've had this question before, why can't you file directly with the court? So you can't file directly with the court because the system we're using currently is Odyssey. Now, Odyssey is a system that is used by 26 other courts, and I think 18 of them are also using e-filing. And so you have to go through a background thing to become a provider. So you have to have the appropriate security levels, because if something goes wrong and your documents are submitted incorrectly, or if some type of virus comes in, it takes down the whole state. Same idea with, like, you can't just have PDFs and submit them email to the court. It's just not a thing that's going to happen. So, I mean, Matt, you could probably talk about that more, but that's my basic spiel about e-filing. I really think if you work on your document descriptions and document titles, that will speed up your filing. Like I said, if you have notes for the clerk, please use that message to the clerk section. We do read those. Okay. Other than that, I think if we have any further questions, or Matt, you have anything to add?
No, we do have quite a few questions that have come through, though, so
okay,
we kind of work through those.
Yeah, let me get out of here. Stop sharing. Okay.
So we have a couple that came in the Q&A. So maybe we'll just start there.
Sure.
Notice of rejection, which we believe is vague or made an error. No one's perfect. How do you recommend addressing that?
I would recommend giving us a call. Give me a call. If I'm here, I will take your call and we can discuss what the issue is. Otherwise, either if you think it's vague or something like that, the clerk who answers the phone could either give you a more explanatory reason, or if I'm not here to talk to one of the leads, they all know what's going on. And if there is an issue, we don't have a problem fixing. I mean, new clerks are coming in all the time, and it is a complicated process of civil. It's a big thing. So I mean, mistakes happen, and we're more than willing to fix them as they come.
And then by next hearing, do you mean the next hearing that relates to the documents or any other hearing in the case?
I generally mean
I think I know the answer to that, but yeah.
Yeah, I generally mean any other hearing that's coming up. I really want to know what's coming up next.
And then I'm going to go. We started getting questions very early on. So let's see. New local rule goes into effect July, e-filing confidential documents. How do we delineate between lodging those documents and filing them?
So there is a lodged document. Well, it says lodged order / judgment. I mean, if you're lodging them that way, and they're specifically supposed to come in that way as confidential, I haven't looked at that new local rule yet, so I'm probably going to have to double check that. But there is a way of lodging the documents with us. I know for a while there, especially on the e-filing FAQs, it talks about documents under seal. And you're supposed to submit the redacted versions to us, and then the unredacted lodged versions are supposed to go direct to the courtroom. So I'm going to have to double check on that one and look at it again, just to see what that new local rule specifically is saying.
I think we answered why can't attorneys file directly like in federal court. I think you covered that. One person's asking for a resource that explains more slowly and completely, I did go fast, how to put tabs on electronic exhibits, although I wasn't trying to do that. I'm going to put, One Legal has a little how-to on this that I'm going to put in the chat right now. That's one resource. But all the programs that you use will have how-tos on bookmarks. It's actually pretty straightforward.
Good.
I got to go back up. Let's see here. Why does the e-filing system reject PDF when it is saved in original format, but will accept the same document if it is printed, then scanned and e-filed? I guarantee you, I don't know the answer to that.
I don't know the answer to that either. That's a very tech question. In the PowerPoint, I had that link to questions for Odyssey at the very end. I'd put that question in there and see what they come back with.
How do you file a stipulation when the first paper fee has not been paid?
Sure. So you can file a stipulation. Basically, you're gonna have your stip. So if you're paying a first paper fee at the same time, you're gonna waive the stip fee, right? And so you can just do stip. What you can do if you're trying to pay a first paper fee in optional services, there's a spot for you paying first paper fees, and it'll let you pay an answer fee, and it'll let you pick 1, 2, 3, or however and how many answers you were trying to do at that time. But that's how you would actually do it. You put it in the optional services.
And then there's a couple. They answered. We're going to send a copy of the slideshow. There seems to be a character limit for the document description. Can we abbreviate the description to get it to fit? Example, PLTFS for plaintiffs.
Absolutely, you can. As long as it's close enough, you can tell the document description is very close to the filing description. I do run into that a lot where I'm taking the filing description and it is way too long. I will cut it way down and make it, I'll just abbreviate, just like you said, PLTF for plaintiffs is totally fine. MPA for memos of points and authority. That's fine.
Are proposed orders under review until the judge signs them? For example, FOH is in family law.
So currently for civil, we are testing out taking orders like orders after hearing, submitting them to the judge through e-filing and having them sign that. And those will be under review. Currently, Judge Fannin is the only judge working on that right now. She's trying to kind of figure out the whole system and if she likes it, if she wants the other judges to use it. But yeah, it will be under review until she signs it, sends it back to us in the clerk's office, and we file it. Otherwise, any other department that we're just taking the order and lodging it and submitting it in paper, it's going to be accepted.
We covered the general average number of days for processing. There's a question about attorneys attending hearings online in guardianship and custody cases and the requirements. I'm going to have to defer that because that's not really an e-filing question. I believe that's on our website, but I'll look into that and I'd have to ask to figure out exactly. I'm aware the probate and guardianship windows are only open for a short amount of time. Can we file multiple cases at a time?
So I don't know if that's talking about like the examiners, they are open a limited amount of time, but I mean, the clerk's office, if you're filing in pro per, we're open from 8 to 3. And if you have new cases, you can come in and file them. Or if you're picking up, let's say, orders after hearing for a probate or a civil, and you want to bring it down to the clerk's office for filing, we can do them same day.
What's the actual lead time in submitting lodged documents? I don't know if you covered this. I submitted an adoption agreement in order 4 days in advance. The court had not seen it at the hearing.
Yeah, I don't know where family law is on that type of stuff.
Yeah, okay. We might do something specific then at that. They're asking for a specific number. So when we talk about a call, and I know there are issues with getting through on the clerk's office line, what the number is that they should be calling.
It is still the standard 925-608-1000. It's the standard clerk's office number. Pick Martinez, civil. I called it yesterday. It just depends on how many people we have here answering phones. We do get a lot of phone calls. So I would say if you're looking to get a clerk, don't call between 12 and 1. We have less clerks available to answer your phone calls at that time. Generally by 2, well, I would say early in the morning is probably best, around 10. We are making an effort to answer all your phone calls.
There's some kind of back and forth on text searchable documents. What I mean by that is that people should be able to do essentially a command to search for particular terms. There is a way to do that. And it actually, Andrew, correct me if I'm wrong, but do they become text searchable? I mean, when they're sent into the e-filing, the format that they're going to be in is going to be text searchable.
Yeah, it's PDF when it comes in, and then when it goes into our system, it is all text searchable.
Okay, so I wouldn't worry too much about that. Then they don't need to worry too much about that because once they e-file, we'll get a text searchable document.
Yes.
Okay. Do we have a particular PDF version? Regular PDF or PDF-A?
Yeah, as long as it's not protected.
Either one? PDF?
Just regular PDF is fine as long as it's
okay.
not a protected version.
And that's the end of what I see in the chat that we hadn't already answered. So unless there are any other questions, we're right on time here at about 1 o'clock. So unless there's any other questions, I guess we will close it out. How can we get a copy of the slideshow? We'll send it to you. All your so just to sum up, the materials and the links to the rules and the slideshow itself will be sent to you at the conclusion of this. If you have questions, you call as before, or I'm sure you can send those into the Bar Association. They can send them over to us and we can deal with any questions that you might have after this or after you've kind of looked at a copy of the slideshow too. But with that, I think we are done. And thank you everyone for attending. I know it's a lot of material, and I know the system is very, 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 very new, and it takes some getting used to. Trust me that it takes some getting used to on our end as well. So we're all kind of together as a team trying to figure some things out. But we're trying to perfect it, and we're trying to error correct. The writs of execution, for example, that Andrew was talking about earlier, is one of those things. We find out that things are not as effective as they could be, and we try to course correct as we can. So we appreciate everybody's patience as we work through it. I do think this is obviously a system that's going to be, as people get used to it, much more effective than prior methods.
Thank you both so much, and thank you everyone for attending. You'll get an email in a couple of days with all the materials they talked about during this presentation and with your attendance certificate. Thank you, Andrew. Thank you, Matt.
Thank you.
Thank you, guys.
Thank you, Andrew and Matt, for taking time to do this for us, not once, but twice, and for really making it easy for everyone to figure this out. And we appreciate you being open and available for all these questions. So thank you very much.
Absolutely.
All right, guys.
All right.
Thank you.
Have a good one.
Bye-bye, guys. Thank you,
Bye.
guys.